Hi, if you may be facing a federal court misdemeanor offense, you may ask yourself, why is this in federal court? In today's video, I'm going to speak to you about that issue and the process that you may be facing going forward. There are really three main reasons that your misdemeanor offense or citation will be in federal court. And those are: one, that your event or alleged offense happened on a military installation; two, that your offense or event took place on a natural wildlife preserve in the state of Oklahoma; and third, and finally, your event may have taken place on other federal ground or on tribal land. The determination of whether your case will be in state or federal court is not only based on where it took place, there's also the subject matter. So if you're involved in something that is specifically under federal rules or alleged federal violation, then that case will most likely be in federal court. However, if you did something that allegedly is in a state court setting, then that most likely be in state court. However, here's the rub. When you do something that is historically a state court issue, such as a traffic violation, a DUI, possession of drug, or other minor offenses typically characterized as a misdemeanor offense, if those events took place on a federal installation or federal land, then they must be handled in federal court. The reason being that state court does not have authority to make decisions or to hold you accountable for things that happen outside of state land, which includes federal territory. Next, I'd like to talk to you about the process that you will almost certainly face in federal court. One of the nice things about federal court, it is standardized across the entire nation because it's federal rules and regulations. So if you're facing a federal court misdemeanor in Oklahoma or Texas, or based on something on this installation or this installation, you will face the same process and procedure because your event took place on, again, federal land. So let's talk about that process. First and foremost is the arraignment. This is your opportunity to be notified of what the allegations or the charges are, what the statutory basis or where the law is that says you can or cannot do that specific thing. And you're notified that you can either enter a plea of not guilty, which gives you the opportunity to contest what the state is alleging you did. They hold all the burden. They must prove your guilt beyond a reasonable doubt, the highest burden in the United States, with a unanimous jury verdict in order for you to be found guilty. Otherwise, you will be acquitted of the charges. The next option is for you to enter a guilty plea, and that is the exact opposite. That's where you take responsibility for the allegations against you, and you will receive some type of agreement or sentence by the court. Third and finally is an interesting middle ground, and that's what's called a no contest plea, or in Latin, nolo contendere. And what a no contest plea means, you understand that the government has evidence that they could present against you, and you decide to no longer contest those allegations. You maintain your innocence, you do not enter a guilty plea, but you grant the court the authority to sentence you within the punishment range. Now that we've covered what a federal misdemeanor case is, why it may be in federal court, what type of charges there are, and what process you'll face at that initial appearance, I'd like to speak to you now about another important consideration. Do I need an attorney or not for federal court? My advice to you is that you should have a lawyer represent you. There's a few benefits I'd like to speak to you about that it is in your interest or your loved one's interest to not only retain a counsel on your federal misdemeanor case, but before you go to court. If you retain competent counsel or a fierce advocate, and they are representing you prior to the court date, they can reach out to the U.S. Attorney's Office, the federal prosecutor. They can express the issues and concerns that you have about the case, your defenses or what you claim they cannot prove or is misrepresented by law enforcement or a federal agent. And that gives the government the opportunity to evaluate that and decide if they're going to dismiss your case or offer you some type of better resolution than you may face in court, or if they don't listen to you and they're going to fight your case, they're going to take you to court. With that information, you can make an informed decision when you decide if you're going to A, take your case to trial, or B, if you're going to work out an agreement or let the court decide the outcome. It's important to know that with a fierce advocate, you have the opportunity in federal court to learn before you go to arraignment if those options exist. Another important consideration in having counsel with you for your federal court misdemeanor is the opportunity to show that you are taking this matter seriously. You're not only appearing in court, but you've retained an attorney to assist you, and you're ready to stand and contest the government's case. Unfortunately, the fact is that if you appear with a lawyer, the government will have to take a second glance at your case and evaluate whether they want to go to trial against you and your attorney, or whether they're ready to cut a deal for you. The last issue that I'd like to discuss with you is what else an attorney can do for you. Having a fierce advocate on your side to help you fight your case is vital if you know that you are innocent. If you need to go to trial or present your case or contest what the government is saying, whether you don't believe the government's case or whether law enforcement is misrepresenting something, or you know that the law doesn't meet the facts of your case, it is vital that you have a fierce advocate with you to fight your case on your behalf. A fierce advocate that's got experience trying cases can not only tell a compelling story to the jury, but can also file motions appropriate to discuss legal and factual issues that the court will decide before the jury is sworn in the panel. Second, a fierce advocate or attorney with trial experience can also speak to the prosecutor and identify issues that they may reconsider before deciding to try your case or not and face your attorney. Third, your attorney can subpoena witnesses, evidence, and compel things to court to tell your story and show the government and your jury that you're in fact not guilty of what you're alleged to have committed. Finally, it is so important to have a fierce advocate at your side that believes in you, because when you stand before that jury and you tell your story with the assistance of your fierce advocate, if that jury sees not only you believe in your innocence, but you have an attorney that cares for you, knows your case, and is fighting for you, that believes in your innocence, it tells a compelling story to that jury. I'm attorney John Cannon with Cannon and Associates, and we are your fierce advocate. If you have questions about these or other issues, we welcome you to visit our website for more information. You can call us any day of the week, and we ask you to subscribe to this channel for more useful videos and information for you and your loved ones.